For admission, item numbers 1 and 2.
Yes.
May I please, Lordship?
Advocate General is not appearing.
Lordship, General is appearing
Oh,
from
okay,
BC, and I'm grateful that he could make available Lordship today.
Yes, yes.
Since an important notification issued by the state of Nagaland, if it is not sustainable, it's going to be interfered with. Therefore, I feel that the presence of the learned Advocate General will also be very helpful.
Yes,
So
definitely.
I'm grateful
Definitely.
for that, Lordship. Background, there are two cases taken together. One is WPC 134 of 2025, and the other is 138 of 2025. But documents in both the cases are similar, so I will confine to WPC 138,
138.
where we have challenged the notification of 9/9/2021. So, in order to decide this, whether this notification of 9/9/2021 is sustainable in the eye of law or not, first, we should understand the concept and the policy framed by the Government of India, because we are dealing with the central pole of MBBS seats, which is allotted to the state of Nagaland, Lordship. Now, kindly come to the writ petition and page 28. This is the letter which I have referred to your Lordship the other day, 9th December 1986. I'll be going a little slow because this is a very important matter, and then once Lordship, this Honorable Court takes a decision, then it will be a very important decision because it is being questioned for the first time. 9/12/1986. I will just refer to the three paragraphs. What is the concept? Why the Government of India was compelled to issue this notification? So, may I read, Lordship? Because this is very important. As you are aware, we have been allotting MBBS BDS seats to your state for the selection and nomination of eligible candidates. Some instances have, however, come to our notice where some of the allottee agencies have not followed. This is also important, Lordship. For not complying with the direction of the Government of India, they are compelled and constrained to issue this. The relevant instructions issued by the Government of India while selecting and nominating candidates against the seats allotted by us. Allotted by us means that is the central pole. Number two, it is once again reiterated that only, the word only is very important, Lordship. Only, whether the petitioner is also included among the only ones. Only the children of permanent resident of the state, union territory. 2, employees of the state, union territory, government concerned. 3, the employee of the central, other state, union territory, government on deputation to the state, union territory concerned. 4, we are in this. The employees of the central, other state, union territory, government hosted in and having their headquarters within the state, union territory concerned will be eligible. Only those who are coming under this will be eligible. So I'm coming under Roman 4 of paragraph 2, and so far as eligibility is concerned, as per this notification, they are not questioning even now also. 3, the children of central, state, union territory government employees aforementioned should be treated at par. This is also important with the local residents. The entire core issue involved in the case is this one. Should be treated at par with the local residents. The sole criteria for the selection will be the academic merit of the candidates. This they have included NEET because this was before introduction of the NEET. So now we go by NEET. Subject to any special orders issues with the concurrence of the Government of India. Now, with the concurrence of Government of India, if there is any modification, deviation from the Government of India, then the concurrence of the Government of India should be taken. And the concurrence for obtaining concurrence of the Government of India is only in this letter. And after this, till 28/7/2025, this notification has been consistently followed. And at the time of filing the writ petition, we have made categorical contention in the writ petition. In both the cases, till date, state government has not countered on this point. Rather, they said that we have obtained the concurrence. That means they are accepting the fact that, yes, concurrence of the central government is required. So, on this notification, I am relying only on these 3 paragraphs to show that this is the guideline issued by the Government of India. And by filing WPC 134, we have also taken the ground that, look, the state government has not taken the concurrence of the Government of India for framing this rule. Now, that is the background. How first notification has been issued. And then in 2015 also, the Directorate of Technical Education has reiterated this 1986 letter also, that instruction given in 9 December 1986 should be followed. Now, we have the...
Then every year, similar instructions.
Yes, correct, Lordship. Now, can we come to our affidavit in opposition in the present case? Page 15 of affidavit in opposition in the IA, Lordship.
Yes.
IA 144 of 2025.
Page 15, and that should be.
Yes, this is the Government of India Ministry of Health and Family Welfare letter dated 28 July 2025. This is the comprehensive governing guideline for all central pole MBBS seats allotted to the states. Comprehensive guideline issued by the Government of India for central pole, and this was issued only to 9 states, not all over the country, because there are so many states where there are sufficient medical colleges, sufficient facilities, but then those central pole seats, after collecting by the Government of India from different medical colleges, and it becomes the central pole, and the central pole is being allocated to few selected states, that is 9 states as is covered in the letter, and the state of Nagaland is one of such states to avail the central pole MBBS seats. And for this academic session, that is 2025-26, there are 42 central pole seats, and our issue in the present case is confined only to that. One thing we should make it very clear that the allocation of the central pole seats, MBBS seats, is not to all the states. It's only confined to 9 states, which is mentioned in this particular letter.
Yes.
Now, let us come to page 16, next page. In paragraph 9, on the top of the page, Lordship will find the state of Nagaland in the second line after Meghalaya.
Yes.
We are concerned here with paragraph 9. Selection of candidates by beneficiary states. 1.1, beneficiary states. the states union territories which are deficient in medical education, 1.2, that is the eligibility conditions. We are concerned with number 3 and 4, Lordship. Number 3, the employees of central other states government on deputation to the state concerned, and the 4, this is very important, the employees of the central other states union territory government posted in and having their headquarters within the state. Petitioner's father is posted in the headquarter, NCC headquarter. So she is eligible in that. And the second para, this is the Punjab contention where Lordship has to decide. The children of central state union territory government employees aforementioned should be treated at par with the local residents. This is of 28 July 2025 letter by the Government of India, where the condition which was mentioned in the Government of India letter dated 9/12/1986 has been reiterated for this year also. By ignoring this, the state government has framed a different policy, that is of 9 September 2021, by ignoring these eligibility conditions. Eligibility criteria has been ignored and violated. And then can we come to next page, that is page 17. I have shown to your Lordship about what are the eligibility criteria,
Yes.
whether I am eligible or not. 1.4, the selection of candidates. And then under that, 1.4.1, national eligibility cum entrance test. In short, it is NET. May I read, Lordship, that paragraph only? The selection of candidates will be made on the basis of rank obtained in the National Eligibility cum Entrance Test, NET 2025, being conducted by the National Testing Agency. There was pause for a while there because others are not relevant. So, Lordship has seen in the previous page 16, 1.2. That is the eligibility conditions. That is the mandatory requirement issued by the Government of India. And under para 4 also, in that they should be treated at par with the local residents. Under 1.2 para 4, Lordship has seen in page 16. And then 1.4.1, that is the present NEET exam. This cannot be ignored. But the notification which is under challenge, the notification of 9/9/2021 has violated these 3 conditions. That is how we are before this Honorable Court. Eligibility criteria has been violated by 9/9/2021. Now, the defense for the state is paragraph 1.5, reservation. What does it mean?
Yes.
Can we come to 1.5 reservation? The contention of the state is banking on this.
Yes.
The reservation policy being followed, that is very important, being followed. There is already a reservation policy followed by the state. What does it mean? Which policy? That will be very important for this Honorable Court to decide, Lordship. The reservation policy being followed. Since when the reservation policy is being followed by the state, it is only from 9/9/2021 or before that also state was following. That is very important. By concerned beneficiary state will apply on central poll MBBS seat. So, power to make reservation by the state has not taken away the eligibility criteria and cannot take away the eligibility criteria. What are the eligibility criteria? What is the selection criteria also? NEET. The ranking in the NEET and the eligibility criteria cannot be taken away. That is the directive of the Government of India, who has given strict instructions to the states to be followed meticulously. I would like to pause for a while to explain about the policy. Just below that, 1.5 below that, paragraph 2, Lordship will find selection of candidates by Union Territory of Jammu and Kashmir, Ladakh, and all that. This is a different policy. We are not concerned with this. But why I'm referring to this? Because this is the manner how the central government is allotting the seats to different categories. Not only this, kindly come to again page 19, paragraph 3. Selection of candidates by beneficiary government departments. This is for government departments and ministries. We are not applicable. This is also not applicable, but this is how the central pool MBBS seats are being allotted to different organs. And then kindly come to again, next page, page 20, paragraph 4. Selection of candidates by Ministry of External Affairs. There is separate quota and instructions are given in all the categories, Lordship. So I come to paragraph 1. For us, what are the criteria to be followed and fulfilled while exercising the selection of candidates from the central poll by the state? Paragraph 1, 1.2, and again under that paragraph 4, to be treated with the local residents, 1.4.1, NEET exam, merit. These are the eligibility criteria to be followed, not to deviate, Lordship. And the notification of 9/9/2021 has deviated from this on the ground that we have framed a reservation policy on 9/9/2021. So, whether the reservation policy framed by the state is in consonance with the directives and guidelines issued by the Government of India or not. That becomes relevant, Lordship. Kindly come to the writ petition, Lordship. Let us go to the MBN order. The other day, Lordship has also read this notification, but then since we have to decide this, I think it will be better to again revise once. Because our memory is short-lived, we tend to forget also.
Page 142.
This is, yes, 142, Annexure R. This is 9 September 2021. And this is a policy in paragraph 1, Lordship will find. It is an umbrella reservation for few departments. We are not concerned with the other departments like the engineering and allied, agri and allied. We are concerned with medical and allied, that too with the allocation of MBBS seat. It comes under medical and allied. That too central pool. Now, state has framed their own eligibility criteria by reserving 100% reservation, which is contrary to the law laid down by the Apex Court and also contrary to the guidelines issued by the Government of India. kindly come to the eligibility criteria. I'm not reading the paragraph 1 because Lordship is aware of that. Category 1 also we are not concerned. Category 2, this is with regard to the reservation of backward tribes. These are correct. And I should agree that yes, there should be reservation for the backward tribes, which is now agitation. I think today the cabinet meeting is also being set for that. But whatever it is, we are not concerned with that. Category 3, this is what we have challenged there. A candidate belonging to non-local indigenous inhabitants of Nagaland, as per PNR Department's number so-and-so. B, children of non-local state government employees and children of all India service officers born on Nagaland cadre to be eligible under category 3B. The candidate should have appeared or passed class 10, 12 or equivalent from any of the schools within Nagaland, and his or her parents should have been residing and posted in Nagaland for at least 3 years or more. Both the criteria should be fulfilled. So these are the eligibility criteria laid down by the state, which has not been specified in the Government of India letter. Now come to the reservation. Next paragraph, paragraph 2. Reservation. May I read all the 3 clauses? Rest, we are not concerned. The state reserved seats for undergraduate, technical and professional courses are reserved for candidates belonging to the indigenous scheduled tribes of Nagaland as follows. A, backward tribe reservation. 15% of the total seats per course are reserved for candidates belonging to backward tribes of Nagaland under category 2. Not more than 1 seat per tribe per course will be allotted to any backward tribe in a single year out of the 15% reserved seats. This reservation we are not questioning. Backward tribe reservation. Reservation policy under the Government of India letter 1.5. The reservation policy of the state being followed. This policy has been there since many, many years back, and that is being followed. And the Government of India letter is talking about all these criteria, reservations, because we cannot imagine 100% reservation. Now, B, person with disability.
But this reservation in 2ABC is different from the reservation policy, the general reservation policy regarding government appointment.
Yes.
This is different.
Yes.
This is completely different.
But
because there they have the roster system.
Yes.
That
no, there are, for that matter, Lordship, there are so many policies of the state government.
No, but
different policies.
Reservation,
even regarding reservation also from time to time they keep changing. Roster policy has been introduced about maybe 10 years back only, approximately. Yes. I do not know the exact year.
As far as government appointments are concerned, that is the standing policy, reservation.
Yes.
So this is regarding allotment of seats in courses, various courses.
Yes.
So it cannot be said to be that other policy with regard to appointment.
But this is a policy. One thing, this is a policy. Government of India letter says that reservation policy being followed by state.
By the state.
Whether Government of India is saying about this policy or the standing for, because this is a general letter. 1. The Government of India letter 28/7/2025, the guidelines, is a general letter not only to the state of Nagaland but to all the beneficiary states, 9 states.
Okay, let's see.
Yes. C. Because B, we are not, issue is not there. C, the remaining seats. That means up to that 15 plus 5, 20% is out. Now left 80%. The remaining seats, that means all the seats, shall be filled up amongst the candidates belonging to the indigenous scheduled tribes of Nagaland, securing minimum qualifying marks in the entrance examination, including candidates belonging to the backward tribes, based in the merit and preference option exercised by the candidates. So this is the remaining seats. So Lordship has seen in paragraph 2, they have reserved 10% seats. All the 100 seats have been reserved for the indigenous inhabitant. Whether that is legally valid or not, Lordship has to examine on that. Can we come to next page, Lordship? And this reservation, before coming to the next page, this reservation has not left any scope to give selection preference to others other than indigenous inhabitants. All India service, even if they are found eligible, this has not left any scope. This has not treated the children of All India service at par with the local residents. This has distinguished, which is contrary to the Government of India guidelines. Now, one illustration, Lordship. Even if I passed class 10 and 12 from Nagaland, as mentioned in this notification, and even if my father is posted in the Nagaland headquarters, NCC headquarters, for the last 5 years, so 1 and 2 both qualified, eligible, still then, I cannot be eligible because I do not belong to non-indigenous inhabitant of Nagaland. That is what the reservation policy says. Then, is it not directly in contravention of the Government of India directive or letter? Has the Government of India letter says anything about the reservation of this? Rather, instruction says you have to strictly follow, and you are violating the guidelines, so follow. That is what the Government of India letter says. Can we come to next page, page 143? Selection. How selection is to be made? A. Selection of candidates to various reserved undergraduate, technical and professional courses shall be through entrance examination conducted by the state, central government, order agency as notified by the state government. B. Only those candidates who secured the required minimum qualifying mark in the entrance examination shall be considered for selection. C. Selection shall be made based in order of merit of candidates in the entrance examination result, preference option exercised by the candidates and availability of seats. Separate merit list shall be maintained for all categories. D. D will not be relevant. E. We are concerned with this. If seats are available, this is very important. If seats are available, after selecting all eligible and qualified candidates belonging to recognized indigenous scheduled tribes of Nagaland, then selection of candidates under category 3 will be considered. Preference will be given in the following order: candidates belonging to non-local indigenous inhabitant of Nagaland, children of non-local state government employees, and children of All India service officers born on Nagaland cadre. When all seats are allotted and reserved, then where is the question of allotting the seats from category 3? If I have understood correctly this clause, preference will be given, and after selecting in the MBBS, I applied for that, I was selected in that, and then if I refuse, after selection also, no, I don't want to study MBBS, then only those seats which nobody wants to take will be given to this category E. And over and above this, the state maintain a separate waiting list. Waiting list. Once a candidate who is selected out of the 152 seats, and if one decline, waiting list number 1 will come and claim, I belong to indigenous inhabitants, so this is my share. Does it sound reasonable? This is absolutely in contravention of the Government of India guidelines. After exhausting all the seats, how there can be any seats? how there can be any selection? How can you expect me to be there? So the objective is just to eliminate the category 3. Nothing else. And here, I was referring to the concurrence of the Government of India while referring to the notification of, letter of 9 December 1986. If the beneficiary state wants to have any alteration, the concurrence of the central government should be taken. That is clear. And here in the letter down below, Lordship will not find endorsement of any copy to the Government of India. That means it can be taken for granted that the consent and concurrence of the Government of India has not been taken. And going by this notification, what about the merit list in the NEET? Even if I secure possession 1, I will not be selected in that case. Then in the process, will it not amount to violating all the guidelines? Who has allotted the seat with some guideline, instructions to be followed? It becomes meaningless. And if paragraph 1.5 is to be interpreted in such a way that, look, state government has been given the power, absolute power to make reservation, then what is the requirement of giving the eligibility criteria and the selection criteria to be based on merit NEET exam? Eligibility criteria has been ignored.
Okay, let me ask you something.
Yes.
In case the petitioner is not successful, petitioner has other options also. Petitioner can
Where?
always apply in the general NEET quota merit list if she comes in the merit list, or in her own state also. That option is also there.
This honorable court is not assigned to decide on that issue.
No. This is just off the record. This is
May
not,
or may not
this is
have.
not the only option.
May or may not have, but I have no instruction on that. And we are, so far as we are concerned, what the Government of India notification, OM says, and what the 99/2021 says, whether it is legal or not, legally sustainable or not.
Because many other officers have also come and gone, those who have worked in Nagaland. Their children have also gone without the Nagaland quota, they have gone to other medical
May have gone.
colleges. Yes.
If they have,
That means they have other options also.
if they have appealed that, that will not compel me to avail the same. What the law says, this honorable court has to decide what the law says.
That will consider, of course. This is just off the record. Yes, okay, then.
And then now that there are two opinions, the petitioner's contention is Government of India guidelines is to be followed. State is contending in 1.5 that the reservation will have a reservation policy that do not qualify the petitioner to be selected. So what the law says on this issue. So I have done a lot of research, but I will confine only to 3 judgments which are vital and relevant so as to decide this, what the law says. That becomes very important. I will confine only to the relevant paragraphs, Lordships, to save time. The first one, Lordship, 1984, 3 SSC, 654, and then if we go by online, it is 1984 SSC online, Supreme Court 127. This is a judgment of 3 judge, Dr. Sandeep Jain and others versus Union of India and others. Here, the domicile issue, and then the argument which was advanced by my learned friend the other day about the concurrent list and all that, and to what extent the power given to the state has to be exercised by the beneficiary states while framing the rules, These are discussed in this comprehensively, and it was decided on 22nd June 1984. And kindly come to paragraph 8. I will not refer the detailed paragraph. This issue has dealt with all undergraduate and postgraduate MBBS and postgraduate PG course also. Paragraph 8.
Yes.
I will refer only to lines. Lordship may kindly come to paragraph 9. Just above that,
Just above paragraph
6 lines I will read. The sentence starts with, we ought therefore. This is the finding arrived after discussing so many things on the law made by the state under list 3, that is under concurrent list. We ought therefore strongly urge upon the state governments to exercise this wrong use of expression domicile from the rules regulating admissions to their educational institutions and particularly medical colleges, and to desist from introducing and maintaining domiciliary requirements as a condition of eligibility for such admission. And then kindly come to paragraph 10. Has your Lordship got paragraph 10?
Yes, paragraph 10.
3 lines above paragraph 10, continuation of paragraph 9. The sentence starts with the question. To understand paragraph 9, this is relevant. The question is whether such reservation or reference are constitutionally valid when tested on the touchstone of Article 14. Now, paragraph 10, I will just take your Lordships to paragraph 11. Above that, I will read only 5 lines. The sentence starts from the primary consideration. Has Lordship got it?
Yes.
Yes. The primary consideration in selection of candidates for admission to the medical colleges must therefore be merit. The object of any rules which may be made for regulating admission to the medical colleges must be to secure the best and the most meritorious student. So it talks about merit only. Now, kindly come to paragraph 20. This is very important paragraph. I will read the entire paragraph, paragraph 20 and 21. Paragraph 20, on the top of the page, Lordship will find. Has Lordship got it? May I read, Lord? The only question which remains to be considered is as to what should be the extent of reservation based on residence requirement and institutional preferences. There can be no doubt that such reservation cannot completely exclude admission of students from other universities and states on the basis of merit, judged in open competition. Krishna Ayurji rightly remarked in Jagdish Saran case at pages so-and-so, reservation must be kept in check by the demands of competence. You cannot extend the shelter of reservation where minimum qualifications are absent. Similarly, all the best talent cannot be completely excluded by wholesale reservation. So, a certain percentage which may be available must be kept open for meritorious performance regardless of university, states, and the like. Complete exclusion of the rest of the country for the sake of a province, wholesale banishment of proven ability to open up, hopefully, some talent, total sacrifice of excellence at the altar of equalization. When the Constitution mandates for everyone equality before and equal protection of law, may be fatal folly, self-defeating, educational technology, and anti-national if made a routine role of state policy. A fair preference, a reasonable reservation, a just adjustment of the prior needs and real potential of the weak with the partial recognition of the presence of competitive merit. Such is the dynamic of social justice which animates the three egalitarian articles of the Constitution. We agree wholly with these observations made by the learned judge, and we unreservedly condemn wholesale reservation made by some of the state governments on the basis of the domicile or residence requirement within the state or on the basis of institutional preference for students who have passed the qualifying examination held by the university or the state, excluding all students not satisfying this requirement, regardless of merit. We declare such wholesale reservation to be unconstitutional and void as being in violation of Article 14 of the Constitution. So no elaboration is required. It is crystal clear like a distilled water, Lordship, in a bottle. Paragraph 21. Here in paragraph 21, Apex Court says that you cannot exceed 70% while reserving the seats. Let me read, Lordship. But then, to what extent can reservation based on resident requirement within the state or on institutional preference for students passing the qualifying examination held by the university or the state be regarded as constitutionally permissible? It is not possible to provide a categorical answer to this question, for, as pointed out by the policy statement of the Government of India, the extent of such reservation would depend on several factors, including opportunities for professional education in that particular area, the extent of competition, level of educational development of the area, and other relevant factors. It may be that in a state where the level of educational development is woefully low, there are comparatively inadequate opportunities for training in the medical specialty, and there is large-scale social and economic backwardness. There may be justification for reservation of a higher percentage of seats in the medical colleges in the state, and such higher percentage may not militate against the equality mandate viewed in the perspective of social justice. So many variables depending upon social and economic facts in the context of educational opportunities would enter into the determination of the question as to what in the case of any particular state should be the limit of reservation based on residence requirement within the state or on institutional preference. But here the opinion of Apex Court. But in our opinion, such reservation should in no event exceed the outer limit of 70%, the total number of open seats, after taking into account other kinds of reservations. Validly, the outer limit should not exceed 75%, but we are of the view that it would be fair and just to fix the outer limit at 70%. We are laying down this outer limit of reservation in an attempt to reconcile the apparent conflicting claims of equality and excellence. We may make it clear that this outer limit fixed by us will be subject to any reduction or attenuation which may be made by the Indian Medical Council, which is the statutory body of medical practitioners whose function obligations include setting standards for medical education and providing for its regulation and coordination. We are of the opinion that this outer limit fixed by us must gradually over the years be progressively reduced, but that is a task which would have to be performed by Indian Medical Council. We would direct the Indian Medical Council to consider within a period of 9 months from today whether the outer limit of 70% fixed by us needs to be reduced, and if the Indian Medical Council determines a shorter outer limit, it will be binding on the states and the union territories. We would also direct consideration at the end of every 3 years, but in no event should the outer limit exceed 70% fixed by us. The result is that in any event, at least 30% of the open seats shall be available for admission of students on all India basis, irrespective of the state or university from which they come, and such admission shall be granted purely on merit on the basis of either all India entrance examination or entrance examination to be held by the state. Because Lordship is well aware, state was conducting an examination earlier on its own, other than the need now. Those are the policy of the government, Lordship. Of course, we need not add that even where reservation on the basis of residence requirement or institutional preference is met in accordance with the directions given in this judgment, admissions from the source or sources indicated by such reservation shall be based only on merit, because the object must be to select the best and most meritorious students from within such source or sources. And then in the conclusion, Lordship may kindly come to page 24, paragraph 24, sorry. This will be the last paragraph in this paragraph 24, may I read? The decisions reached by us in 3 writ petitions will bind the Union of India, the state government, and administration of Union territories, because it lays down the law for the entire country. And moreover, we have reached this decision after notice to the Union of India and all the state governments and Union territories. I will end there. After about 19 years, another judgment was passed. This judgment has been upheld by a constitution bench in 2003, Lordship. And I believe after the judgment was passed in this case, apparently, I'm not saying that in terms of this, up to 2 years, about 2 years, the notification of 9 December 1986 has been issued by the Government of India.
This is 2003.
And 2003, Lordship. Here, I will just refer to very limited paragraphs, Lordship. Here, again, it has been reduced to 50% after 19 years. This is a constitution bench. And then, in this particular case, Pradip Jain, which I have just referred to, Your Lordship,
yes,
has been relied and referred also. Paragraph 103 to 108. Paragraphs are very short, but I would have preferred to rely only in paragraph 108, but in order to have the connectivity, it becomes necessary to refer to the other 3-4 paragraphs, which are very, very short, Lordship. Has Your Lordship got it? It's in page 184, paragraph 103. This judgment was slightly modified in 2025 in the latest judgment, but then not deviated in the principle, Lordship.
103, yes.
103. Similar view was already taken by this court in Pradip Jain. This is the one which I have referred to. 104. Let us leave that. 105. In the case of Article 15.4, reservation, this court has made it clear that the claims of national interest demands that this reservation can never exceed 50% of the available seats in the educational institutions concerned. 106. The view was approved by this court in the case of Indrashoni versus Union of India, and other cases also there. I am not referring to this. And then paragraph 107. Of course, as between the reserved category candidates, there should be industry merit observed. This has been emphasized by this court in several cases. 108, this will be important. And out of this paragraph, after reading the first paragraph, I will take your lordships to paragraph 3 and 4. 108. As regards the constitutional validity of institutional, regional, university-wise reservation preference, in view of this court's emphasized on the need to strive for excellence, which alone is in the national interest, it may not be possible to sustain its constitutional validity. However, the presently available decisional law is in support of institutional preference to the extent of 50% of the total available seats in the educational institutions concerned. So 50% ceiling has been met. And then kindly come to paragraph 3 and 4 of the subpara, paragraph 108. May I read paragraph 3? As regards the scope of reservation of seats in educational institutions affiliated and recognized by state universities, the constitutional prescription of reservation of 50% of the available seats has to be respected and enforced. 4. The institutional preference should be limited to 50% and the rest being left for open competition based purely on merit on all India basis. So this is the law laid down by the Apex Court. Lordship is well aware under Article 142, a law passed by the Supreme Court shall prevail over the territory of India. Now, up to this judgment, the latest judgment, Lordship, after many years, on 29 January 2025, Dr. Danvi Phil judgment has come on 29th of January 2025, where all the judgments with regard to the medical admission has been scrutinized by the Honorable Supreme Court. And this is a case of postgraduate. Actually, day before, Lordship was expressing about some judgment that some distinction has been made between UG and PG. Exactly this is the case, maybe, Lordship, because this judgment has been widely circulated in the social media and all other forums.
Yes, this is
in
the
the
one done
media.
by Ben.
Yes, this is a case from Union Territory of Chandigarh. Actually, the case was pertaining to postgraduate, PG, where the Supreme Court has laid down that question of reservation do not come even near. PG, super speciality, purely merit, nothing else. But some concession has been given to the states for the UG. Local-based concession has been given, but that too with the limited scope only, not the wholesale, as has been laid down in the Pratip Jain's case in 1984, Lordship. And incidentally, this judgment was passed by Sudhanshu Tholia, who was the Chief Justice of this Honorable Court, and Heshikesh Justice Heshikesh Roy is also there. He is also from this Honorable High Court, Lordship. So it is a judgment of 3 judges. Similar policy was framed in the case of Union Territory of Chandigarh. Lordship will find in paragraph 1 and 2, the base given. They have met the ceiling of 5 years that students should pass study for 5 years. Parents should also be posted there for 5 years. And the parents should also possess property for 5 years. The similar guideline has been framed by the Union Territory of Chandigarh. But ultimately, what the Apex Court said, Lordship, I will refer few paragraphs. Hopefully, I will not be able to finish that. After this, I will just sum up my summation, Lordship. But kindly come to paragraph 14.
1-4.
I am taking the Lordship only to the relevant paragraphs. Paragraph 14 of the judgment. Dr. Danvi Phel. Yes. Lordship got it?
Yes.
The difference in the logic in making reservation on the basis of residence in UG level or MBBS level. So as I was mentioning, Lordship, although the case was about the PG, but principles for MBBS, UG has also been laid down here. MBBS level, the PG level, MT so-and-so, was explained in Jagadish Sharan as well as Pratip Jain. It was held that at PG level, merit cannot be compromised although residence-based reservation can be permissible to a certain degree. Lordship may kindly take note of this. Residence-based reservation can be permissible to a certain degree in UG or MEB's course. That is very important. Not all, not 10%, to a certain degree, while coming down heavily on residence-based reservation in PG medical courses. It referred to the opinion of the Medical Education Review Committee relied upon in Saurabh Chaudhary's case. And then paragraph 15. Why residence-based reservation is impermissible is for the reason that such reservation runs counter to the idea of citizenship and equality under the Constitution. And then a lot of discussion has been made, but then just above paragraph 16, few lines, Lordship. In the quoted para, last 3 lines, the judgment, this is paragraph 10, I have already read paragraph, some portion of paragraph 10. What is necessary is equality of opportunity, and that cannot be met dependent upon where a citizen resides. It is not on the basis of the residence that. Now, come to paragraph 21. Here they have referred to Pradip Jain. In Pradip Jain, the argument that domiciliary requirements for admission to medical colleges and other colleges situated within the state territory is used not in its legal sense but in a popular sense, denoting residence or an intention to reside permanently, was also discussed. And this practice of wrongly using the nomenclature domicile was condemned. And then quoted portion. I have already referred this paragraph in Pradip Jain's case, so let me not read in detail. But in paragraph, page 19, paragraph 21, towards the end, this, in our opinion, is a dangerous feeling which, if allowed to grow indiscriminately, might one day break off the country into fragments. So, Supreme Court has given caution to the states. Paragraph 23 and 24, I would like to read, Lordship. Short paragraphs are there. Paragraph 23 and 24. Has your Lordship got it? Yes. May I read, Lordship? In the same judgment, it was also explained that merely because a state legislature makes law on certain subject matters, it will not ipso facto mean that persons residing in that state have a provincial domicile. The competence of legislature is not limited to passing of law which would only apply to persons domiciled within the state. Any law passed by a state legislature can be applied to any person within the state, and therefore the expression domicile has no relevancy whatever in constructing the competency of the state legislature. If the state legislature is legislating on a topic within its competence, that law can be made applicable to anyone in the state of Mumbai, whether he is a resident or not, or even if he is a foreigner passing through the state of Mumbai. Therefore, it is fallacious to suggest that the doctrine of domicile is introduced in our law by person of the fact that the state or the provincial legislature has been given the power to legislate with regard to the certain subject matters within its territorial ambit. It therefore seems to us that the expression domicile used in any state or provincial law is a misnomer, and it does not carry with the implications which that expression has when used in the context of international law. 24. In short, the very concept of a provincial or state domicile in India is a misconception. There is only one domicile in India, which we refer to as domicile in the territory of India as given under Article 5 all Indians have only one domicile, which is domicile in India.
Okay, let's continue to.
Yes, just I'm finishing.
Yes. Yes.
I was referring to the last judgment and
Yes, you have
particularly
finished, I think.
paragraph 24, I was referring with regard to the domicile, where the Apex Court has made an observation that all Indians have one domicile. That is the domicile of India. So I was referring to that in the paragraph 24. And so far as the father of the petitioner is concerned, he belonged to All India Service. Lordship is very well aware that the posting of any single government employees can be at any time within a week, within a month's time also I may be transferred. The father of the petitioner cannot be a domicile of all the states in the country. So only one domicile, that is the domicile of India. Giving in view of these problems, in the guidelines also, only the children of the All India Service. Guideline doesn't talk about domicile and all this, but the states have been committing mistakes by making law basing on the domicile. This judgment was compelled to be passed by the Apex Court, making observation on the issue of domicile. Now, I would like to refer to paragraph 29. I will just 2-3 paragraphs only that
The same
on this judgment, and this is the last judgment I am relying. Paragraph 29.
Yes.
Lordship, may I read, Lordship? It is now necessary to refer to the detailed reasoning given in the chain as to why residence-based reservation in PG medical courses is violative of Article 14 of the Constitution of India. To maintain a balance and for consideration of local needs, such reservation may be permissible in MBBS course. In the initial stage, I was also referring that although the main issue of this Chandigarh's case is pertaining to the PG, but then principle has been laid down with regard to the MBBS also. That is, in short, in other words, UG, MBBS. The reasoning gives us that it is the state which spends money on creating infrastructure and bears the expenses for running a medical college, and therefore some reservation at the basic level of a medical course, that is MBBS, can be permissible for the residents of that state. The classification between residents and others here can be justified at the classification, as the classification seeks to maintain a balance as it considers local needs, backwardness of the area, the expenses borne by the state in creating the infrastructure, etc. So here, to maintain a balance. Discretion has been given to the state to make reservation in the MBBS level to maintain a balance. Balance between what? The state and the center. That means state is not absolutely free to make 100%. I will just cite an example in the NIMSA. Lordship is well aware because it pertains to our state, Nagaland Medical College. We have 100 seats. And I believe mostly the fund is being funded by center because we are a backward state. We should all admit that also. Now it has 100 seats, 85 seats purely for state, 15 seats that is left with the center. During the counseling, even this year on 4th August 2025, 15 seats were not included among the 85 list. For allocation and maintaining this, state has the power to make law. And this 85 seats. 15% they have not touched and not included in the counseling this year. Why? State has the power to make law on reservation on this 85. Out of that 85, the Quad tribes reservation this much will come. That is left with the state. That is how the reservation policy is applied. That is how it was left out from the counseling also. 15 seats. Out of 152, 82 seats pertains to NIMSAR and 85 seats. For that, state has absolute power to utilize in whatever manner they want to use. They can frame rules, reservation, everything. But they have not touched 15 seats. It was left open. How to fill up this post, 15 posts? On the basis of what? On the basis of need merit. It has to be filled up by merit. And it was left open. That way, nobody has questioned this. Because there is a policy. Now, next paragraph 31. After this, I will conclude in paragraph 33. Paragraph 31. Has the Lordship got it? May I read it also? This is all about talking about domiciles. We are all domiciled in the territory of India. We are all residents of India. Our common bond as citizens and residents of one country gives us the right not only to choose our residence anywhere in India, but also gives us the right to carry on trade and business or a profession anywhere in India. It also gives us the right to seek admission in educational institutions across India. The benefit of reservation in educational institutions, including medical colleges, to those who reside in a particular state can be given, and this is framework, to a certain degree only in MBBS course. This is very important, Lordship. To a certain degree only in MBBS course. Power has been given to the state to make reservation, but it is not absolute. To a certain degree only in MBBS course, for which we have assigned reasons in the preceding paragraphs. But considering the importance of specialized doctors in PG medical courses, reservation at higher level on the basis of residence or be violative of Article 14 of the Constitution of India. This has been explained with pronounced clarity both in Justice Saran and Pradip Jain. If such a reservation is permitted, then it would be an invasion on the fundamental rights of several students who are being treated unequally, simply for the reasons that they belong to a different state in the Union. This would be a violation of the equality clause in Article 14 of the Constitution of India and would amount to a denial of equality before the law. No illustration is required, Lordship. Very clear, in clear terms it is given. And last paragraph I would like to refer, that is paragraph 33. Yes. May I read, Lordship? Having made the above determination that residence-based reservation is impermissible in PG courses, that is PG, that is impermissible, I was saying that it is 10% merit. State quota seats, apart from a reasonable number of institution-based reservation, have to be filled strictly on the basis of merit in All India examination. Thus, we are coming to the facts of this particular case. Out of 64 seats which were to be filled up by the state in its quota 32 could have been filled on the basis of institutional preference, and these are valid. But the other 32 seats earmarked as Union Territory Chandigarh pool were wrongly filled on the basis of residence. And we uphold the findings of the High Court on this crucial aspect. So the finding of the High Court has been upheld by the Honorable Supreme Court. What is the finding of the High Court? Lordship will find at para 4 of the judgment. Para 4. Lordship will find in the sub-para. The sentence starts with, be that as it may. Has the Lordship got it?
Yes.
Yes. Be that as it may, the High Court held that there has been a violation of Article 14 of the Constitution of India in granting such reservation. Consequently, the clause 2b, Roman 1, 2, and 3 were declared invalid and unconstitutional, and all admissions which were made by the placing reliance on the above provisions were held to be bad. It was directed that the medical college should now fill these seats according to the merit positions of candidates which they have obtained in their NEET examination. Very, very clear, in clear terms, the Honorable Apex Court has given the finding that residence-based and Clause 2b, 1, 2, 3, it's similar like us. Such an observation was made. Supreme Court said that this is bad in law. So it was interfered with. And they directed to fill up the post seats on the basis of the merit. Now, that is all about the law, which the law of the land, the Apex Court has laid down. Now, I would like to refer to my affidavit in opposition. A short affidavit has been filed. Annexure C, page 22, affidavit in opposition. Annexure C, page 22. Has your Lordship got it? This is the calling letter to the petitioner, call for participation in the NEET, so and so, and this has been issued in terms of the order passed by this Honorable Court on 30th July. The Lordship has passed that order, and I have been informed to participate in the NEET UG 2025 State Counseling, scheduled on 4th August 2025 at 10 a.m. in the Directorate of Technical Education. So accordingly, I have been intimated and submitted the representation. Page 24. It was addressed to the director. It was on 2nd August. Call for participation in the NEET UG 2025 State Counseling scheduled on 4th August 2025, Directorate of Technical Education, Nagaland. Please refer to your call letter number so-and-so dated 1st August 2025. 2. In this regard, I have already provided a copy of relevant court order and my options of colleges for purpose of counseling. The same has been handed over to your office, white letter dated so-and-so, dated 1st August 2025. That is why, on the basis of my listing, they have called me for the counseling and the representation which I have submitted on 1st August 2025. Lordship will find it page 23. Court judgment, case number so-and-so. And I will read from, this is addressed to the Director, Technical Education. Number 1, please refer judgment of Kohima Pinch, Gauhati High Court, number so-and-so, dated 31st July 2025, copy enclosed for reference. 2, white para 8 and 9 of the above judgment, Honorable Court has directed to reserve one seat from central poll for the undersigned. 3, choice of seat. In line with the court directions, I am exercising the choices of MBBS seat for the central poll counseling as under 3.1, 3.2 in the name colleges, first choice, second choice, third choice, for up to 6 choice I have given. So the colleges are there. Number 4, you are requested to reserve one seat for MBBS from the above choice as per my NEET merit and as per the governing directions of eligibility and seat selection for central poll seats as laid down by the Government of India, Ministry of Health and Family Welfare. Any subsequent financial litigation or any other liability arising due to non-compliance or wrong considering my choice by the Directorate of Technical Education shall be borne fully by the Directorate of Technical Education, Nagaland. That is on 1st of August 2025, after this Honorable Court passed the order. Then I participated in the counseling, but merit was not considered, and the choice of colleges which I have given already allotted. On the ground that no, High Court order have not specified where to reserve. They are becoming wiser than this Honorable Court. So, one seat which was reserved was in the bottom. But one thing which is very clear, that the list which has been prepared by the Directorate on the counseling is all provisional, not final. And this preparation has been done by the Directorate in spite of my representation 1st August 2025. And if it goes as per the arrangement made by the Directorate, then merit has given a go by. Government of India instruction is also ignored. The order passed by this Honorable Court is also not acted fully. By ignoring my representation, they have proceeded to go ahead like this. Therefore, if at all any difficulty is being faced pursuant to any direction by this to be passed by this Honorable Court, it is the who has created the problem. So when you create a problem, you should find a solution to your own creation, own created problem. It is not created by me. Rather, I have taken all the necessary appropriate steps at appropriate time. But then they have ignored the prayer, because all I have to do is to do in accordance with the provisions of law, which I have done, Lordship. So this is how the things have developed for non-compliance of the guidelines issued by the Government of India. Now, coming to the conclusion, Lordship, I just want to conclude.
Yes.
Category 3B of the Indian order. Category 3B, that is page 142 of the writ petition, Lordship. In 86 guideline also, that is 9 December 1986 guideline, this guideline is not there. And in the present guideline which I have been referring, 28 July 2025, this condition provision is not there, not included as part of the guidelines of Government of India. Therefore, the guidelines issued by the Government of India for the central poll MBB seats have been violated. Now, in the initial part of my submission, I have been referring to the guidelines issued by the Government of India, particularly paragraph 1.2, that is with regard to the eligibility criteria. Yes. And then, especially the sub-para 4, it is written in figures 4. Where there is a clear provision that the children of the central service should be treated at par with the local residents. Why this is mentioned, Lordship? The logic behind this is, Lordship is well aware, any person who is in All India service, they have transfer liability, especially the defense personnel who are in central service, they may be posted for 1 year, 2 years, maximum, so far I know, is 3 years. They have all India transfer liability. So far as the father of the petitioner is concerned, he is serving in the Indian Army for the last 28 years. And at no point of time, he was serving for more than 3 years. So he cannot be a domicile of Nagaland, he cannot be a domicile of Assam, he cannot be a domicile of any other state. He born in MP state. But then he is transferred here and there like a shuttlecock, and there is no permanent posting for them. That is the reason why the children of these central service employees cannot be made to study in one particular place and cannot be made to take every here and there as and when the parents are transferred out. Children cannot be afforded to take along with their parents every now and then. Therefore, there is a provision in the guidelines that the children of the central service should be treated at par with the local residents of that particular state. And if I pass an order, issue a direction that all the students should study only in the state of Nagaland, for example, will it be constitutionally justified? You have to study, you have to pass class 10 only from a particular school and particular state. That cannot be. I am talking on the reasonableness, whether it is reasonable. Therefore, fixing 3 years for the parents of the children who are applying for MBBS and to study and pass class 10 and 12 only from a particular state is nothing but to eliminate the non-indigenous inhabitants, which is in violation of Article 14 of the Constitution of India. And for posting for 3 years the parents, it is also unworkable. When it is unworkable, it is unreasonable, because you cannot make any officer to be posted in the state for 3 years. Without completing 3 years, you cannot be transferred out. That cannot be. But that is what the notification of 9/9/2021 says. Therefore, it is violative of Article 14 of the Constitution of India. And therefore, Lordship, the notification dated 9/9/2021 requires to be interfered with by this Honorable Court in respect of selection to MBBS Central Poll, because this notification pertains to 3 branches: engineering and allied, medical and allied, and agriculture, agri and allied. We are not after all this. We are confining specifically to MBBS Central Poll selection, second category. Therefore, we are seeking to quash is not in all, but it confines only to that. Our prayer is also very clear on that, Lordship. Not to interfere with this thing. And one recent development with regard to the admission. Earlier, admission was supposed to be held from 6. Now, as per the latest guidelines, directives of Government of India, All India, admission is from 8 to 16, 8 to 16 admission in the Central Poll quota. Therefore, still time is left for the state departments to make changes on the allocation of seats, allotment of seats, Lordships, and there is time. One disturbing feature, Lordship, there is. I have highlighted the relevant portion and a step to verify need documents.
The indigenous inhabitant.
Now that the matter is pending in the court, and we all know that the proceeding of the court is online, anybody can see what we are also doing. So, I know that I should be careful also. Similarly, whoever attends the proceeding, they should be careful. Looking at that, they are trying to eliminate non-indigenous. Even if, under the law, I'm eligible. So, this is the second method of selection. Whether it is the Directorate of Technical Education who should conduct the counseling and selection, or a student organization should conduct the selection. I bring it to the notice of this Honorable Court. Luckily, the Learned Advocate General is also here, who is the Chief Legal Advisor of the state. I believe if we are to go by these practices, then the entire government has to resign and allow some organizations, civil organizations or the student organizations to run the government. It is a fit case where this Honorable Court should take so much cognizance about the activities.
Yes.
Very sorry state of affairs. But Lordship, the law is very clear. I need not elaborate and then I will not take much time. I initially intended to take 1.5 hours. I believe today also I have done justice to the case, Lord.
Okay.
To the time.
Yes.
Much obliged, Lordship. And of course, I reserve some right to reply on
Of
the
course,
submission
sir,
of
that
this.
is always there. Yes.
Please. I don't think some of those adjectives used towards the end was really required. Using such unmitigated, harsh terms on the government. This is not a case for that. Because you have to understand the situation in Nagaland. If you go by the case law, the question of reservation started in the famous case of Balaji versus State of Mysore in 1963, where the reservation given was 68%, where the Supreme Court reduced it to 50%. So like that, like ping pong ball, it is going from 50, 60, 70, like this, it is moving around here and there. The first question for consideration, what we see in Nagaland, we have to see the realities. Law should be based on realities. A situation like this has not been considered of by any court, including the Honorable Supreme Court. The situation prevailing in the state of Nagaland. I remember in 2006, if I'm not mistaken, there was a PAL in the Honorable Gauhati High Court for preventing the Christian Medical College Bello from taking over the referral hospital. Certain interested parties in the medical side filed this PAL not to get it. So their submissions appear to be reasonable to the Honorable then Chief Justice. I said only one thing, that if you have any heart attack or problems in Nagaland, nobody can save you. That is the situation in Nagaland. He just lifted the file and put it, take it. The referral hospital is yours. This is the situation in which we are. We don't have, even today, a multi-specialty hospital. After 6 decades, we are getting a medical college for the first time. And in these 6 decades, all the students from different states were exposed to medical education in their own states. There are a number of medical colleges in places like Andhra and Karnataka. They're too numerous. They're in three figures, if I may say so. So they had that opportunity to get medical education for the last 6 decades. For the first time in the history of the state of Nagaland, we are getting this opportunity for the first time. And therefore, to say the government is like this and like that is totally uncalled for. It's only playing to the gallery. Therefore, if you see various other realities in the state of Nagaland, even the question of reservation. In the Legislative Assembly, 59 seats are reserved for scheduled tribes. 59. Because that is the ground reality. It does not obtain in other states. And also, when it came to women reservation, we did not give reservation for whatever reasons, which required a correction from the court. And the government accordingly agreed to it, that they should be given that reservation. So in this type of situation, we cannot expect the various decisions which are being given, where there are umpteen number of colleges. Now, here is a student who has studied in a good school, maybe in the capital or elsewhere. I'm not talking about this particular student, any student for that matter, who's entitled to come under this category. Whom are they competing with in the state of Nagaland? Many children who are going to village schools, not to too well off schools. So forcing them to compete with that itself is a clear breach of Article 14 as far as state of Nagaland is concerned. And see the financial power of state of Nagaland. We live on the oxygen of the center because of so many problems. So our resources are very limited, and whatever belongs to us, constitutionally belongs to us, that is being denied. So it is in this situation when this problem or this solution cropped up in 2023, when we had the first medical college. A small window was given to the state. That window was applicable to whoever could avail of it. We never asked for anything. The central government said that as far as your guidelines are concerned, we will not interfere. Just for a moment, if I may take the Honorable Court to writ petition number 134. 134.
134.
134 or 138? 138. I'm sorry. 138. I'm sorry. 138. I'll read the second paragraph of paragraph 7. May read page 7 of 138. Page 7. Internal page 7. Writ petition 138, second paragraph.
Yes.
The breakdown of MBBS seats available to the state of Nagaland are a total of 152 seats as Directorate of Technical Education notification dated 24 July 2025. As per the notification, a total of 152 seats for MBBS are available to the state, and out of the 42 seats are Government of India seats as central pool being provided to the state as one of the beneficiary states getting assistance from the Government of India, Ministry of Health and Family Welfare. The allotment of these 42 central pool seats to applicants is governed by the guidelines and directions given by the central ministry issued annually while releasing and providing these seats to the beneficiary states. So the fact that we are covered by these guidelines is a fact admitted by the petitioner in this case, which means these guidelines have to be looked into. Just at the cost of interruption, I want to point out, they are not coming under the All India Service. That's completely erroneous statement. An army officer does not hold an All India Service post. All India posts are given under Article 312 of the Constitution of India, where you have the All India Services specified, you have the All India Services Act. All these are different. So throughout he has been saying it is All India Service, it is not All India Service.
No, but in the ministry guidelines, it says children of employees of central
Central government.
central state posted in and
Correct.
having their head.
Correct. But you can't call it All India Service, because throughout he is claiming that we are All India Service, we are transferred from here to there. That's different. All India Service is completely different. They come under a different act. Army comes under the Army Act. They come under the Air Force Act. They come under all those manuals, etc. They're different. I was just saying that we should not use terminologies which do not actually apply to our case.
Okay, understood.
Right. Now, as far as the guidelines are concerned, I will just take this honorable court to I've given a compendium for this court's MOVA that is there. Very good. Now, the honorable court sees internet page 15, 1-5.
This is 13 August 2024.
Central Pool MBBS and BDS seats allocation for the year 2024-25. I'm directed to forward herewith a statement indicating the number of MBBS BDS seats along with the college concerned allocated to your state for the academic session 24-25 from the central pool. Following points may be considered. It's once again reiterated that only children of permanent residents, employees of state duty government concerned, employees of central other state government on deputation to the state duty concerned, employees of the center other state duty government posted in and having the headquarters within the state concerned will be eligible. 1. Children of central ST employees aforementioned shall be treated at par with local residents. No, 5% of the seats allotted to each state concerned will be reserved for physically handicapped. Selection is made as per disabilities. The admission of candidates to various colleges will depend on their fulfilling the eligibility criteria, conditions of admission, and other requirements as laid down by the concerned institution. State government may be ascertained from the concerned college. The selection of eligible candidates will be made as per the guideline issued by this ministry's letter of even number dated 12th August 2024. So the guidelines are given in 12th August 2024. Now kindly see page 19. 19.
Yes.
This is again same 12th August 2024. The undersigned is directed to refer to the subject mentioned above and to enclose herewith the guidelines to be followed by the beneficiary government department for selection and nomination of candidates against central pool seats for the academic year 2024-25 for information necessary action. So now this is the guidelines. And the actual guideline is coming on the following page, where you have the same eligibility criteria, etc., education qualifications, tests, etc. And page 21, 1.5. The reservation policy being followed by concerned beneficiary state, UT, will apply on central pool MBBS BDS scale. So this is not something I have demanded. I am bound by this. There's no difference of opinion on this issue because central government has seen what is the state of Nagaland. They know where the law and order situation can also trickle. So they say, whatever is your policy, we will not interfere. It's a different thing. He may say that Supreme Court has picked a moratorium of 70%, 50%, 40%. But it is not a state took the law into its own hands to do any of these things. We were bound. This privilege was given by the central government that you can have this. It is in these circumstances we had a policy. Maybe that policy may not align with many other things which my learned friend might have mentioned. But the policy was crystal clear. We gave reservation in such a way we wanted to protect our children. True. Why? Well, they had no scope of getting any type of improvement in their status. Because as I have mentioned, for the last 6 decades, they had not got this opportunity. A golden opportunity, belated opportunity only came now. And we are starting with a problem in that also.
Yes.
Even in those cases where our children go outside the state to eke their livelihood in accordance with law, they are prosecuted, they are arrested in neighboring states like Punjab, etc., like criminals. And those who are the authors of the crime, they go scot-free. And people are in a disarray where to send them. This is the situation we have here. So, if you see even other areas of reservation, in 6 decades, we may be having, I don't think we have 2-digit number of high court judges in the state. Which state has got this problem? The neighboring state, 4 judges are appointed at the drop of the hat. We don't get. So what I'm trying to impress upon the court is, I've come into this picture at a very last belated stage with rudimentary papers in my hand. We have to understand that we have to lift our children also who are sinking by the day. And if the central government gives us this, and it is a policy of ours, our policy will be different from other states in every way. We have delimitation problem. Policy here is different. Take any of these problems, our problem is different. So the Honorable Supreme Court is also trying to see how to manage the situation. No coercive steps are normally done. So we have been treated as a class. And the Constitution speaks of special powers, etc., privileges. But what are we getting? We are not getting what the neighboring people are getting. So are we not entitled when a minuscule of just 30 seats, 40 seats are there? And our vibrant children, you will see the literacy rate of Nagaland. It will catch up with Kerala in a very short time. Should they be just doing lower strata of work, or they are also entitled to go up just like their others? Can we be kept out? Is a short question. Even the decision which my learned friend had pointed out of Justice, our former two judges of Justice Sudhanshu, etc., that is January 29th, 2025 or so, they have been very lenient to this extent that as far as undergraduates are concerned, they must be
It says
given.
to a certain degree. The state government can relax to a certain degree only.
That's right. I'll come to that degree also. I'll come to that degree.
Not absolute. That's what the Supreme Court
Yeah,
says.
I'm coming to that. May not be absolute. I'm saying that even the thinking of the government on these lines is today slightly different because we are seeing the legal position, the natural problems, and when they see it from step to step, like the question of domicile, etc., these are things which definitely the government will address. But how do you put a candidate who comes from a renowned school, who has different opportunities in her state, and this is a bonus, coming and taking away the seat of a humble child, where the government has been striving to get a medical college for over 60 years? Can it be treated as violation of equality? It is violation of equality as far as that student of Nagaland is concerned. Equality means treating the like alike. This would be a case of treating the unlike alike. And if the unlike are treated alike, there is absolute violation of Article 14 of the Constitution. For this, we have to understand the realities, not just law. So if it is the central government who is a party to this case. Unfortunately, I don't think they filed any affidavit. Therefore, why don't they come forward and give their views, their clarification in this matter? It's not something affecting only the state. If they were to say that you are not entitled to this, or you are given blanket discretion to us, you go ahead. As far as that reservation is concerned, you do it. It was not put with any strings. Notwithstanding the constitutional limitations given by various decisions of the Supreme Court in the peculiar facts and circumstances of the state of Nagaland. If 1, 2, 3, 4 seats go, there is total violence, total law and order situation that our people have not got it. Not that we are justifying it. Because for them, it is everything for them. Every family is trying to get it. They don't have the money to buy seats. That's the third way of getting seats. People have enough money and they, whatever way they do it, they get seats. We have nothing. So in my respective submission, the Union of India, who has been notified of this case, should come and clarify this question first. Instead of our taking a view this way or that way, it's not just the various decisions of the Supreme Court. It's not that. I'm not saying they're not relevant, definitely are relevant. But that has to be applied to a particular case in a particular way. And the way we are going ahead.
Learned AG, the problem is the central government, they are not getting the instructions, and there is urgency in this case because the admissions are starting from 8.
I agree. I agree. At least since they have been notified of this, at least tomorrow they can come make a submission, even a day, or two, because after all, they are the ones who are given the. Suppose they say, how do you reconcile? On the one side, you say you can give like this, and the other side, they say this is the question. Central government has never questioned these views given by us.
But the 42C center has not still fixed the date for the admission.
Even for the 42 seats which are here right now, they have not fixed the date for admission. That's what I'm told. But that's a different matter altogether. I'm only saying that just like this, there may be a prospective candidate waiting somewhere with the hope that he will get it or she will get it. Now, what happens if one seat is reduced? That person's seat goes off and he doesn't even have the right to contest. Because by the time he wants to agitate this matter also, he will be nowhere. He or she will be nowhere. So all just like the petitioner has genuine problems, I won't say the problems are not genuine. We have to also consider the problems of our children also, our students who are aspiring for it. So to get a very concrete position on this, I'm not going into the challenge of the various decisions. As I told this honorable court, right from 63, this has been going on. How much should be given, how much should not be given. This is going sometimes up and sometimes down. And 100% reservation is not the order of the day. But these are things which can be looked into. I am only saying, let the views of the central government come. Normally, in the cases what we will have, I will just explain this honorable court. We have a dispute on the border between Assam and Nagaland. The central government is like an arbitrator. And what do they tell the court, Supreme Court? We don't want to cross this. We don't want to cross this witness. Oh, this is no way. You can't abdicate your responsibility. If you have not permitted this, we would not have gone in for this. So I think their views, at the earliest, in whatever form, be it just they file an affidavit in whatever way they want, if that is placed on record, that should be the end of the matter. I'm aware that we are running against time. Even today, the central government council, whoever the learned council may be, he may be apprised of it, get instructions in whatever way he wants, and let us see how they reconcile this question. Because they should not have given this unfettered right. That's a policy of yours, we will not interfere. If they have given this right, that itself conflicts with what they are saying earlier, that you give like this and you give like that. So a man-made confusion exists. So it will be in the fitness of things that the central government comes into the question.
I don't know whether learned CGC will be able to give an undertaking like that within 2 or 3 days.
I think they should be able to give.
Basic
No,
issue,
no, actually, that the ideal position would be that the CGC, the central government also gives their opinion.
that is what I pointed out
We
day one.
will wait for 3 days. Just a minute. We wait for 3 days. If nothing comes, then leave it to the court. At least they are not, when you're federal setup, when it's federal setup, they have a constitutional obligation to come and explain. You cannot leave the states to the mercy of this violation, that violation, not complying with this. They have an obligation to answer as to how this was permitted, in what context this was permitted. We exercise that. Give them 3 days. I'm sure that if appropriate instructions go, they will come and clarify the point, whatever is the point. And once that is clarified through authentic records and affidavit is filed to that extent, matter will be clarified. Our only position is this: we are not the authors of this confusion. So, as this honorable court has pointed out, that would be the ideal situation. Let them get proper instruction and file an affidavit on that. That should be the end of the matter. This is my respectful submission. I'm not blaming the candidate or anything. She has merit. We respect merit. Not poking fingers at anybody or making another statement. Complete justice.
Lordship, I'll say that come up on Monday. I'll try to get instruction. In the meantime, since IA has been filed for modification of the court order, that order should stand till the disposal of this.
That order is still there. The only thing is now that IA has been filed, it should be disposed of within 2 weeks, that's all.
In that case, I'll seek instruction.
Monday,
Right on Monday.
It'll be Tuesday. We have to go to Itanagar, I'm told.
Chief, may kindly,
One day. If it's possible, otherwise, I don't know, additional AG will
Petitioner
apply.
of the Advocate General, I would like to reg, will it go over?
It's not inconvenient.
I was expecting, with due respect, I was expecting that the learned Advocate General will argue how notification issued by the state of Nagaland on 9/9/2021 is justified in the eye of law. I believe, considering the issues involved in this writ petition, the pertinent question is whether this 9/9/2021 notification is valid in the eye of law or not.
yes, exactly. That is the question, yes.
Yes. Therefore, it should be argued that, no, I have made my submission, how it is heretical, how it is constitutionally invalid. Let the learned Advocate General make submission on that this is justified. Just because they could not make any justification, the matter has to be delayed. Can that be? Almost like a political speech that Nagaland is placed in a very different situation. Do you mean to say that the rule of law is not applicable in the state of Nagaland? The law of the land cannot be applied in the state of Nagaland?
That is not our subject.
It should be treated differently. In what manner? In what respect it should be treated differently?
I will explain it in a minute.
Petition has been filed under Article 2 to 6 of the Constitution of India that the petitioner is a citizen of India and entitled for rights and privilege guaranteed under the Constitution of India. As a citizen of India, law should be treated equal to all the citizens of the country. So also, the state of Nagaland is governed by law. That is how the functioning of the government, whether it is union or the state, it is under the Constitution, under the law. Not that law made by the parliament or the state legislature, state can make any kind of law. That is not. What is the issue involved in this particular case? We are not asking any seat from the NIMSA. It is not relevant to make such a submission also when we are not asking the seat in NIMSA. We are talking about the central poll. And that is what the petition has been filed for that.
No,
And any submission is relevant for NIMSA, for that matter.
the question is the policy, the guidelines of the central government on which the learned AG is talking about, this 1.5
Yes,
reservation.
that's why.
So
I
that
will come to that.
clarification.
I will come to that.
Yes,
In fact, he should argue, basing on that, how 9/9/2021 is justified.
I should not be advised how to argue.
By
You can argue.
referring to the petition, by referring to the paragraph 7 of the writ petition, petitioner do not belong to all industries. That is absolutely misplaced. How can we come to the guidelines issued by the government of India?
no,
The latest.
the court has also noticed that employees of the union state.
Yes, that is suffice. And the reason given by the state for not including in the list of the selected candidates is given in the IA paragraph 7 of their petition, which this honorable court has converted as person order to be treated as affidavit in a possession of the respondent. The other day, Lordship has passed.
Yes, yes.
Our memory is very fresh, and that So that is the reason given.
The criteria.
Learned Advocate General wants to say so many other irrelevant reasons. But whether we have to go by any wishful thinking of some person, or we have to stick to the affidavit and the pleadings made in the petition. The reason given in paragraph 7 by the state is that as per the 9/9/2021, you are not eligible and qualified. I have made my submissions on that point by citing so many laws. So
I will just add
this
one
honorable
point.
court has to decide.
No, see,
Government of India
the
has
only
given the
problem
guidelines.
is Government of India has been made a party in this petition.
Yes.
As respondent number 5. So I think it is only fair that they should also be heard. That is the only thing.
And even the 42 seats which he is mentioning as central pool, it is actually a reservation for the state also. It's not 100% goes to them.
It's for the state.
It's for the state. From that they may get. It's not 42 is reserved for them. State is also entitled to this quota. And when he says that everybody is equal under the law, all the states are equal, then how do you explain Article 371A? Now, all the states in India get Article 371A.
Article 371A has nothing to do with this particular case.
State will have its
That
own
is absolutely misplaced.
and special privileges. And if I
Absolutely
say I'm not arguing the question as far as the other points are concerned, what has to be borne in mind is that as far as this is concerned, we are not the defaulters. We have been advised by the central government. So we are only asking that limited question. Let them come and answer. And I say, I don't want to say anything more. How is they are prejudiced by that?
Since CGC is also saying that we can try on Monday, we'll listen on Monday then.
That's right.
Lord Chief, on Monday,
Yes.
my learned friend has filed IA, submitting that it is very urgent. In the light of that, it was fixed
Because
on
of
Tuesday
that, it was fixed, yes.
for hearing. Then the submission made was on the next day. I think the learned advocate general is coming. I do not know for which he is coming, but let the matter be deferred tomorrow. That was the submission. It is on record. Not that he is coming for this case. I do not know for which it is coming, but he is coming. I accommodated, yes. I know that there will be delay. And delay, it is not only my problem. The state will be in the department will be in a big shock.
Everybody's problem, yes. The state
They are
government.
creating the problem. It is their creation. And they are telling day after day.
No, but
One thing is very sure, Lord Chief. I have cited all the judgments, whether 100% reservation is possible or not.
permissible or not.
And that if there is any ruling of the Supreme Court, let the learned advocate general also place. They are saying we have the power under 1.5. 1.5 power has been given with the guideline of the Government of India, not only to reserve seats. That is for a different purpose. So, whether,
No, it says reservation policy followed by the state.
yes.
That's all.
Yes. And I have challenged that reservation policy. And I have argued that there can be no 100% reservation. If at all it is possible, let the learned advocate general even say today. If it is not so, there is no bar for this honorable court to arrive to a conclusion so as to do substantial justice to all the parties. Otherwise, approaching this court, honorable court, will be meaningless. There will be more problem tomorrow. Okay. Because Damocles' sword is hanging over the head of all of us.
No, if the central government's
today
instructions were
they are-
present, even if it's oral, even if oral submission is there, this court would have surely disposed.
Lord Chief,
But-
the
but-
very issue
but
which
when
has been
the-
raised in the writ petition
Yes.
is notification of 9/9/2021 has been challenged that it is not permissible in the IAB law. To decide that, what kind of an instruction is necessary?
They have not challenged the
Clarify,
reservation.
clarify their policy, that's all, to clarify
all.
their guideline. Because
That's
they
it.
are a party. We cannot avoid the fact that they are a party. That
For
is the
that,
only
he
thing.
can obtain
That
tomorrow
is the only
also.
thing.
Nowadays, it
Let
is
them
not emotional.
Let them place it so that instead of making an oral submission, which they may say was not authenticated, let them make a very simple 2 paragraphs affidavit or 3 paragraphs to clarify the question. So what harm will be caused to anybody? The ends of justice would be met. I'm not
Whether
going lock, stock and barrel on arguing with
under
this. I have not done that. I have not
paragraph
done that at all.
1.5, the reservation,
Therefore, this is
They-
the whole portion.
whether the power
And the petitioner has made the central
allowed
government a
under
party.
paragraph 1.5 of the Government of India notification, whether it permits 100% reservation or not.
Petitioner has made central government a party. We have not made.
No, that's why,
Yes.
this
We
court is
have
also,
made the party
this court is also
They
concerned
can't
about that.
escape with
when the
everything and
petition
put it
was
out
filed.
on the head
And the
of the
day of
state
filing,
and then try
copy
to
has
attack
been served. So it is the bounden duty to obtain the
Government will not
instruction.
fall.
I cannot get instructions from them.
No, no, to be very fair, that was 31st July. Today is only the 6th. And central government, for them to get instructions so
But
fast is.
think of
it
the
is
schedule
not
for
possible.
admission. State government has to make changes. By that time, some of the,
Let that be their problem. Let that be.
no,
their
no, that problem will create problem for me. My rights will be taken away.
And the interim order is there in your favor.
It's not using admission.
Interim order is already there in your favor. The learned CGC, Mr. Young Gauhati, has submitted that the instructions are still awaited from the respondent number 5 or 4. Respondent number 5.
Five.
Respondent number 5. And therefore, prays that the matter may be listed on 11th August. Stop. Learned counsel for the petitioner, Mr. Siri Jamir is present. Learned Advocate General, Mr. Ken Balgopal is present for the state respondents. List on 11th August.
Lordship,
2025.
if no
On which
instruction
date-
is
on which
received,
date, an effort will be made to dispose of the matter, considering the urgency in the present case. Yes.
A copy of this order may be furnished to us.
Yes, a copy of this order may be furnished to the learned CGC. Yes, what were you saying? If they don't get the instructions,
if you don't get the instructions again, can there be another adjournment?
it is made clear that the case will be heard.
Considering the urgency involved in the matter.
Be heard even if the CGC does not receive the instructions, considering the urgency of the matter.
The matter shall be decided on the basis of the materials available on record.
That's okay. You've already
Lord.
said it will be disposed of.